What you're about to watch is one of those courtroom cases that raises a difficult question. When should the justice system choose rehabilitation over punishment? The defendant in today's hearing isn't just accused of drunk driving. Prosecutors say she led police on a dangerous chase at speeds exceeding 100 miles per hour, refused to stop, crashed her vehicle, and watched it burst into flames. According to the case, she also admitted to drinking while taking prescription psychiatric medications, creating an incredibly dangerous combination behind the wheel. But this hearing isn't only about what happened on the highway. It's about what happened afterward. Mental health evaluations, competency questions, months spent in custody, and a judge forced to decide whether this defendant deserves another opportunity, or whether releasing her would put the public at risk all over again. As this hearing unfolds, pay close attention to how each side presents its argument. The prosecution focuses on public safety, while the defense argues that treatment, not simply incarceration, is the key to preventing future tragedies. The judge has to balance accountability with compassion, and by the end of this case, you'll see exactly why that decision wasn't nearly as straightforward as it first appears.
PR 42736, the State of Ohio versus Jennifer Wilson. Ms. Wilson is before the court with her counsel, Mr. Adams. Ms. Tranter, on behalf of the State of Ohio. Ms. Tranter.
Your Honor, I believe that Ms. Wilson is prepared to enter a plea today. Is that correct, Mr. Adams?
It is.
She's going to be pleading as charged. Count 1, failure to comply with the order or signal of a police officer is a felony of the 3rd degree. Count 2, operating motor vehicle under the influence is a misdemeanor of the 1st degree. In addition to the facts alleged in the indictment, this event occurred on May the 29th, 2025, Warren County, State of Ohio. Defendant was operating her vehicle at a high rate of speed. Officers attempted to conduct a traffic stop. The defendant accelerated, topping off speeds at 103 miles per hour. It eventually ended up going out the right side of the roadway, overcorrecting, rolled her car multiple times, struck a concrete divider, and the car ultimately caught on fire. She was transported to the hospital. She exhibited both max clues on the HGN as well as the VGN. She admitted that she was on antidepressants and antipsychotic drugs as well as to drinking at the time of her operation of the vehicle.
I am not going to get into the matter of sentencing today, Ms. Wilson. I want to order a pre-sentence investigation, and we'll come back in a few weeks and do sentencing at that time.
Notice what the judge does here. Even though the defendant has already entered a guilty plea, sentencing doesn't happen immediately. Instead, the court orders a pre-sentence investigation, commonly known as a PSI. That's a critical step because it gives the judge a much fuller picture of the defendant's background, criminal history, mental health, substance abuse issues, and likelihood of rehabilitation before deciding on punishment. This isn't a delay for the sake of delay. It's about making an informed decision. Especially in cases involving impaired driving and mental health concerns, courts often need far more information than what's contained in the police report. What do you think? Should judges always gather this level of information before sentencing, or should serious crimes like this result in immediate prison time?
Mr. Adams, you wish to be heard on the issue of bond?
Yes, sir, Judge. There was a period of time where Ms. Wilson's sanity and competency and restoration of the competency was in place. We've seen reports, we've stipulated to the same. I would ask that she be released. And she previously performed well on bond, Judge, when there were the SCRAM or alcohol monitor was in place. Her father and other family are here. I know that she has a place to stay. It was where she was previously staying before. I do think it's probably in her best, as well as to ensure compliance with pretrial conditions, that the monitor be in place. To be candid with the court, I think that gives her the ability to come out of jail and make sure that she is ensured to follow through in the short term. Obviously, that's not a lifetime. We can't put ankle monitors on people for life. So hopefully the skill set that she's able to gain through whatever conditions this court deems appropriate will aid her in that. But I would ask for her to be released. She has a significant amount of time in custody at this point, Judge. It's probably 7 or 8 months. At this point, I don't have the exact number, but she's been in for quite a long time.
Tell me what happened back in October when you were out on bond, and then you were driving again, apparently impaired, and that's before you ended up at Beckett Springs. what happened there. You were on an alcohol monitor. They were getting notifications that you were using alcohol. You then again got behind the wheel of a car and drove somewhere while on monitor. Explain to me what happened in that. Were you cited for that or anything? Is there any charges that came out of that?
I don't think so.
Not that I'm aware of, Judge.
So, okay, so now tell me what happened there, because I mean, I have a concern about the safety of the public. If I'm going to let you out of jail and you're going to drink alcohol, abuse your medications, and then get behind the wheel of a car, that concerns me. Okay, you're not allowed to drive right now. You understand that?
Yes, sir. Yes, sir.
So can you explain to me what happened back in October when I revoked your bond? If you can't, then that's fine. But if you remember and try to explain to me so you can.
I needed help.
I'm sorry?
I needed help.
Here's where the courtroom debate becomes especially interesting. The prosecutor isn't arguing simply because the defendant broke the law once. Instead, she's pointing to a pattern of behavior that allegedly continued even after earlier warnings and supervision. From the state's perspective, this isn't just about punishment. It's about preventing another potentially deadly incident before it happens. Meanwhile, the defense acknowledges the seriousness of the offense but argues that competency issues have since been addressed and that structured supervision could safely allow the defendant back into the community. These competing priorities, public safety versus rehabilitation, are among the toughest decisions judges face every single day. Which side sounds more convincing to you at this point?
Yes, Judge, we would ask she remain pending sentence. I think it's a terrible idea to let her out. I'm reviewing my notes from back in October, and I believe, in fact, I know this is the case that Officer Conroy was down here and spoke to the court about numerous alcohol events. And I think she said there were so many, she in fact blew up her tab monitor. I think she's a very big risk. I think we need to get her assessed and come up with a plan for her before we even think about releasing her back into the community, because I think she's just too much of a danger.
Judge, if I may, in
Sure.
response to that, and I appreciate counsel's thoughts. I understand where she's coming from. I think there were competency issues at that point in time that were still being resolved and or unresolved. Those have, according to the reports that we've all stipulated to, been resolved at this point in time. She has been in custody for enough time that she's had alcohol out of her system. I will certainly, you featured, and I think fairly so, and I've already previously told Ms. Wilson that the state's going to be asking for prison. I clearly will be asking for her to be given credit for the amount of time that she's done and do the treatment and the assessments and things like that Ms. Traynor spoke of, because I think those are important. What I would ask the court is, if we're going to be able to find out whether Ms. Wilson was under competency and or needing help, as she described it, conditions, well, she's received that at Beckett. I think we need to see whether or not she can do this or not. This will be the kind of a little mini probation period. And if she does well, then obviously I'll be arguing, hey, Judge, she's done well. If she gets out and she doesn't do well, then, she knows where her next address is going to be.
Sir, you had something. Sir, would you tell me your name, please?
My name is Gerald Thornton. I'm a friend of the family's.
Okay.
When she was on both monitors, she did extremely well. I don't know what the prosecutor had to say about it, but she was extremely well and went to all the court dates, and we made sure she was there. It is when she had the other monitor off is when things went awry.
This is a significant moment. Instead of keeping the defendant in jail until sentencing, the judge grants release, but only under strict conditions. House arrest, electronic monitoring, alcohol monitoring, and an unmistakable warning that any violation could immediately result in prison. Judges sometimes use this type of release as a real-world test. If the defendant follows every condition, it demonstrates responsibility and self-control. If she fails, the court gains valuable information before imposing a final sentence. It's a calculated risk, and not everyone agrees with taking it. Some viewers will probably think this is an incredibly generous opportunity, while others may believe the seriousness of the original pursuit should have ruled out release altogether.
Okay. All right. Court is going to grant defense request, and I'm going to release Ms. Wilson on an OR bond should be placed both on electronically monitored house arrest and a TAD monitor. If you violate my orders on bond right now, I can guarantee you that when you come back for sentencing, I'm going to send you to prison. Are we clear on that?
Yes, sir.
So you, Mr. Adams is right. You have an opportunity right now to show me over the next several weeks that you will comply with the court's orders, that you won't break the law, that you won't abuse your medication or alcohol, and that you can follow my orders and be a successful candidate for community control or probation. Do you understand that?
Yes, sir.
But if you go out, if you go back to your dad's house and you start drinking again and you're getting behind the wheel of a car, which you're not allowed to do, we're going to have a problem because I will send you to prison for 2 years. And I don't think that's what you want. And that's certainly not what I want to do. I want you to be successful. Okay?
Yes, sir.
Okay. All right. So I'm going to have both, they'll have both monitors put on you and you'll be released. Okay? Anything else we need to do?
No, sir.
All right. Thank you all.
Thank you.
Thank you.
Thank you.
Call me.
PR 42736, the State of Ohio versus Jennifer Wilson. Ms. Wilson is before the court with her counsel, Mr. Adams. Mr. Tranter, on behalf of the State of Ohio, we're here for sentencing. Everyone's had an opportunity to review the PSI.
Yes, sir.
Yes, Your Honor.
Ms. Tranter, anything on behalf of the state?
Now we're at sentencing, and the prosecution makes another important request, a lifetime driver's license suspension. That's a severe consequence, but the state argues it's justified because this is reportedly the defendant's third impaired driving offense. The defense pushes back by pointing out that the earlier offenses happened many years ago and emphasizes the positive progress she's made since her release. This highlights something many people don't realize. Sentencing isn't simply about the crime itself. Judges also weigh recent conduct, rehabilitation efforts, criminal history, and the likelihood of future compliance. The outcome often depends on balancing all of those factors together rather than focusing on just one.
Your Honor, on behalf of the state, as court's aware, it is a fail to comply. This is a charge that our office does ask for prison time on. I do understand the recommendation from probation and understand the reasons for those recommendations. I would ask that no matter what the court's ultimate decision is, that Ms. Wilson be given a lifetime operator's license suspension as part of your sentence. She does, this is her third OVI overall, and I think that the lifetime suspension is appropriate. My understanding is she has 217 days of jail time credit, and with that, I'll defer to the court.
Anything else from probation? Nothing further. Mr. Adams?
Judge, we've had an opportunity to discuss this in chambers with probation. I'd stand predominantly on those comments. The only thing I would highlight is she does have 217 days of credit, as we just indicated. She has done well since the court released her. I know that part of the court's options, certainly I'd ask that the court not sentence her to prison for a number of reasons, most of which I think the court's aware of the mental health component in this case. I'd ask the court to hold the inpatient in abeyance. I think just from looking at her today, I think the court can see, and I can represent that she looks like a different human. She's doing very well. So I'd ask the court to potentially give her the opportunity to stay on the monitor, do the mental health court or mental health program through community control, and see how she does, Judge. I think she's doing well. I don't know that inpatient is necessary right now. If the court determines that that's what's necessary, then we obviously respect the court's decision. As to the license suspension, these are old OBIs. One was, I think, 05, another was 09. She's going to need to be able to get places at some point in time in her life. Her father and other family members are here, but Father Time is undefeated, and so she's going to need to get places at some point in time in her life on her own. I think a lifetime is excessive, so we'd ask the court to impose a reasonable suspension. We understand that there's mandatory minimums, and I'm not necessarily saying that this is a minimum case, but I think a lifetime suspension is excessive.
Ms. Wilson, anything you'd like to say?
I'm a good person. I really made a mistake, and I'm very sorry.
The judge's final sentence tells us a lot about how he viewed this case. Instead of imposing immediate prison time, he orders community control, continued monitoring, mandatory mental health treatment, substance abuse treatment, medication compliance, jail credit, financial penalties required by law, and driver's license suspensions. This isn't a free pass. Community control comes with strict rules, and violating them can quickly result in incarceration. The judge appears to be recognizing both the danger of the offense and the progress the defendant has shown while under supervision. It's a sentence designed to protect the public while giving rehabilitation one more chance to succeed. Whether that gamble pays off depends entirely on the defendant's future choices.
So I'm going to place you into community control for a period of 3 years. You'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from use of any illegal drugs, alcohol, or marijuana. Do you understand?
Yes, sir.
All right. You're ordered to comply with the assessment, and you are to undergo and successfully complete mental health and substance use disorder treatment. You are on medications now.
Yes, sir.
You're ordered to be compliant with the medications. You're not to stop taking them unless your doctor says in writing that you are allowed to stop taking them. Do you understand?
Yes, sir.
I'm going to suspend your license for a period of 5 years on the failure to comply. That license suspension is effective today, 6/25/26. Who are you living with right now?
My father.
All right. I'm going to continue you on the monitor at this point in time at your PO's discretion. You're ordered to successfully complete the corrective thinking course. On the OVI, court's going to order you to serve 180 days in the Warren County Jail. You have 217 days jail time credit. Your operator's license is suspended for a period of 3 years. That to be effective May 29th, 2025. There's a $565 mandatory fine, which the court cannot waive. Other than that fine, the court will find that you're indigent for the purpose of other fines, costs, or financial sanctions. Do you have any questions for me?
Yes.
All right. Mr. Adams, is there anything else?
No, sir.
All right, that's all. Thank you.
Thanks, Judge.
Thank you.
As the courtroom proceedings conclude, we're now about to see the actual police pursuit that formed the basis of these charges. Hearing testimony in court is one thing, but watching events unfold from law enforcement's perspective often gives viewers a completely different understanding of the danger involved. Pay attention to the radio communications, traffic conditions, and the speeds being reported. Officers aren't just trying to stop a fleeing vehicle, they're constantly weighing the risk to innocent drivers sharing the roadway. Every second of a pursuit requires split-second decisions from both police and the suspect. After hearing the legal arguments throughout this case, seeing the footage provides important context for why the court treated this offense so seriously.
Mr. Lucas, King Frank Victor 2387. King Frank Victor 2387. They're gonna stop in front. In the right lane, moderate traffic, 70 miles an hour. Pull up. White female driver, black hair, 40s.
Passing 60 for 18 or 82. Light traffic right now. We're trying to box her in. Stand by. There she sees us. She's totally going around us. I'll try to slow her down. We're coming up to the rest area.
made eye contact with us. I think it's going to be 79.
Clearly, will be down the county line. Traffic.
Off the right side of the road. Right on 31. Right, 31. Start EMS.
Start lost, single line, purposely driven off the red, rolled over about 6 times.
This case ultimately became a powerful example of how modern courts balance punishment with rehabilitation. The defendant admitted guilt after a dangerous high-speed pursuit involving alcohol, prescription medications, and a crash that could easily have ended in tragedy. The prosecution argued that prison was necessary to protect the public, while the defense emphasized mental health treatment, competency restoration, and the positive progress made under supervision. In the end, the judge chose accountability combined with strict oversight instead of immediate incarceration. Community control, mandatory treatment, continued monitoring, license suspensions, financial penalties, and the warning of prison for any future violations all demonstrate that this second chance comes with enormous responsibility. Now we'd love to hear your opinion. Did the judge make the right decision by giving rehabilitation another opportunity, or should prison have been imposed immediately because of the seriousness of the offense? Let us know in the comments below. If you found this case as shocking as we did, make sure to hit that like button, share this video with others, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real legal analysis. We'll see you in the next case.